Crespo versus Mogul, GR number L-53373, June 30, 1987. This is for criminal procedure, specifically on control of prosecution. Question: who shall prosecute criminal actions? Answer: all criminal actions commenced by a complaint or information shall be prosecuted under the direction and control of the prosecutor. Question: when will the authority be deemed terminated? Answer: this authority shall cease upon actual intervention of the prosecutor or upon elevation of the case to the regional trial court. Facts: this case was about the control of prosecution in a criminal case where the information for such had already been filed in court. This was an original case for estafa filed by the assistant fiscal with the approval of the provincial fiscal against petitioner Mario Crespo. At the regional trial court, when the case was set for arraignment, petitioner Crespo filed a motion to defer the same on the ground that there was a pending petition for review filed with the Secretary of Justice on the resolution of the Office of the Provincial Fiscal for the filing of the information. The respondent judge, Honorable Mogul, denied both the said motion and the motion for reconsideration filed by petitioner Crespo. The petitioner then filed a petition for certiorari and prohibition with prayer for a preliminary writ of injunction before the Court of Appeals, which granted the same while awaiting the resolution of the Department of Justice on the petition for review of the information. The Department of Justice, through the Undersecretary of Justice, ruled in favor of Petitioner Crespo and directed the fiscal to move for the immediate dismissal of the information for estafa on the ground that the check involved, having been issued for the payment of a pre-existing obligation, the liability of the drawer can only be civil and not criminal. Consequently, the provincial fiscal filed a motion to dismiss for insufficiency of evidence with the regional trial court. However, respondent Judge Mogul denied the motion on the ground that such motion disregards the requirements of due process and also erodes the court's independence and integrity. Hence, the respondent judge set the case for arraignment. Further appeal on Court of Appeals had been likewise denied. At the Supreme Court, via petition for review, the petitioner prayed for the dismissal of the case and maintained that the information filed against him was not valid and of no legal force. On the other hand, the Solicitor General, in its comment, recommended that the petition be given due course for being meritorious. Issue: whether the trial court, acting on a motion to dismiss a criminal case filed by the provincial fiscal upon instructions of the Secretary of Justice to whom the case was elevated for review, may refuse to grant the motion and insist on the arraignment and trial on the merits. Ruling: the Supreme Court said, yes, the trial court, acting on a motion to dismiss a criminal case filed by the provincial fiscal upon instructions of the Secretary of Justice to whom the case was elevated for review, may refuse to grant the motion and insist on the arraignment and trial on the merits. The preliminary investigation conducted by the fiscal for the purpose of determining whether a prima facie case exists warranting the prosecution of the accused is terminated upon the filing of the information in the proper court. In turn, the filing of said information sets in motion the criminal action against the accused in court. The rule, therefore, in this jurisdiction is that once a complaint or information is filed in court, any disposition of the case as its dismissal or the conviction or acquittal of the accused rests in the sound discretion of the court. Although the fiscal retains the direction and control of the prosecution of criminal cases, even while the case is already in court, he cannot impose his opinion on the trial court. The court is the best and sole judge on what to do with the case before it. The determination of the case is within its exclusive jurisdiction and competence. A motion to dismiss the case filed by the fiscal should be addressed to the court who has the option to grant or deny the same. It does not matter if this is done before or after the arraignment of the accused or that the motion was filed after a investigation or upon instructions of the Secretary of Justice who reviewed the records of the investigation, such as in this case. Therefore, the trial court acting on a motion to dismiss a criminal case filed by the provincial fiscal upon the instructions of the Secretary of Justice to whom the case was elevated for review may refuse to grant the motion and insist on the arraignment and trial on the merits. In applying the foregoing, the petition was dismissed for lack of merit.